thing was that St. Mark's Square was under construction, a lot of refurbishment happening. So
it's okay. You dodged a lot of pigeons. That's what. That's that they love dive bombing tourists in St. Mark's. So I wonder if they still require head cover going into the chapel there. Mm-hmm. My brother and his significant other were traveling there, and she did not have head cover, and they wouldn't let her in. But that was a while ago.
In the Duomo, they were very strict about shoulder and knee coverage in Florence.
Yeah. Just joining us, we're just going to wait another minute or two before we open the program, but so get yourself a nice cup of coffee and relax and get ready for what I think is going to be a terrific presentation from Cassie Rogers. Good morning, everyone. Welcome to this installment of the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy, and we're coming to you from the virtual world of She and Finney. And this is our October event, breakfast event with our HR friends. We've got over 175 people registered, and people still filling in, but I'll just take a minute or two to talk about what's coming up, and then talk about some related housekeeping issues. But our next event will be issues to consider with a post-pandemic employee handbook reboot. Many of you had lots of other things to handle during COVID, and updating your handbook was not a priority. Perhaps you did sections of it. Our partner, Karen Whitley, will cover that November 15th. December 13th is our annual wage and hour top 10 list. That's the top 10 wage and hour violations under New Hampshire law. And we also cover federal law as well. And I'll be doing that program. That's our annual review of wage and hour issues. And then we've got Sarah Jane Hogue doing our financial wellness. Starting the new year, oftentimes we look at everything from diet to finance. And this will be financial wellness, the do's and don'ts when investing for your retirement. And as everyone gets sort of closer to that point, you want to look at smarter investments and so on. So this is something to share with HR professionals and employees. And so we're looking forward to that program. So these programs, as you know, we do have HR credits for this program, which typically goes from about 8:10 to about anywhere between 9:15 and 9:30. And at the end of the program, you'll see a slide that deals with the HR credits. But no worries, because Liz Tezick will, for all people registered, will be sending out an email afterwards with a link to the recording of this program, as well as information on the HR credits. So we are a well-oiled machine in that regard for sure. So moving back to today's topic, I am thrilled to introduce a litigation associate from our firm, Cassie Rogers, who I think is an exceptional lawyer. and many people agree with me. In fact, I can't think of anyone that doesn't. And she's taking time out of her busy schedule to deal with what is a relatively hot topic these days, and that is religious accommodations in the workplace. Now, you've always had religious accommodations in the workplace, but in the last few years, perhaps with COVID, but with other issues, it's become more of an issue for HR professionals. And so Cassie is going to walk through some of the recent cases, recent guidance, and some just general tips on how to avoid some of the pitfalls in this area. So please welcome Cassie Rogers.
Thank you very much, Jim. It sounds like you have a really valuable lineup of events coming up. But as Jim mentioned, we will be here discussing today religious accommodations. So in discussing that, there are many circumstances where an individual's religious observances, beliefs, and viewpoints enter the workplace. Today, we'll be focusing on the ramifications and obligations that arise when the observance of those religious beliefs and viewpoints and such clash with the employee's requirements, their job requirements. And in doing so, briefly, this is the overview of what we'll get into today. First, we'll dive into the legal framework. So we're talking about what are the employer and employee's legal obligations in regards to religious accommodations. Next, we'll discuss the role of the employer in this framework, what the employer is obligated to do. Then we will dive into best practices. So in light of this legal framework and the employer's obligations, what is it that the employer should be taking on proactively in order to accommodate appropriately and legally as they should? And finally, I'll provide some resources at the end for you as employers or an employee to reference as you continue in your areas and as you explore these areas of religious accommodations. So diving into this legal framework, essentially there's a legal framework in which employers must navigate this clash between religious beliefs and the individuals in the individual workplace's requirements and needs. At the forefront of this legal framework is Title VII of the Civil Rights Act of 1964. This is really the primary federal statute that we provide as a guide for religious accommodations. In addition to that, we must look to state and local laws. These state and local laws typically provide a greater protection for religious beliefs and observances. But today we'll be primarily focusing on Title VII in our discussion. With that said, by way of example, when discussing state and local laws that could potentially apply, not all states have additional laws or regulations, but states that do, it's very important for the employer to tune in and to really stay engaged in what regulations or what laws are being implemented. Specifically, by way of example, New York City has provided additional requirements in regards to the need to engage in an interactive process. So under Title VII, as I'll discuss further today, the employer is obligated to engage in an interactive process with the employee regarding their need for religious accommodation. So that's a dialogue with the employee discussing what their belief is and why this accommodation is needed. But under New York City law, then you additionally, in addition to having the dialogue required, you must document this. But additionally, this must be done prior to making any determination regarding the accommodation. And finally, you must provide a written determination as to whether the accommodation will be granted. That's in a far more extensive requirement than what is required under Title VII, but that is some of the types of additional requirements that state and local law could implement. Another type that we've seen, again, in New York, but at the New York state level, or as well as in New Jersey, there are requirements as to what can be regulated in regards to employees' hairstyles. Particularly as of now, this is more based in race, preventing racial animus, but we could see this extend into the religious accommodation sphere as well. And these are the type of things that you as employers should be on the watch for these statutes being enacted. But with that said, shifting to our focus for today, Title VII of the Civil Rights Act of 1964. This has, as do most things, has experienced quite the evolution, particularly in regards to what religion is, what the standard is for employers, and that's what we'll discuss further. But as it was enacted in 1964, Title VII of the Civil Rights Act of 1964 prohibited and continues to prohibit covered employers from failing or refusing to hire or discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's religion. And when it says covered employers, that means a person that is engaged in an industry affecting commerce who has 15 or more employees for each workday in each of the 20 or more calendar weeks in the current or preceding calendar year. And it includes any agent of such person. So that's where the first trigger there, you have to be an employer that has 15 or more employees. But importantly, what the statute failed to do in 1964 is establish really what is that meaning of because of religion. So it left a lot of gray area for employers and employees to really work and figure out the scope of this. So importantly, and a key player in deciding and determining the scope of this was the Equal Employment Opportunity Commission, the EEOC, which early on in the enactment of this Title VII of Civil Rights Act of 1964, they played an integral role. They established the initial idea of what because of religion is, where it didn't spell out what this meant. They provided guidance early on that provided that to accommodate because of religion, it required that it meet the reasonable religious needs of employees. So the standard was established, and essentially to say that it obligated employers to make reasonable accommodations to the religious need of employees whenever that would not work an undue hardship on the conduct of an employer's business. So let's work through that a little bit. So essentially, undue hardship, that left a little bit of a gray area. What is an undue hardship? And specific to the conduct of an employer's business. So it's looking at hardship, whatever that means, and then the conduct of an employer's business. So what the need of the business is. So those are two factors that the EEOC highlighted as relevant to this standard. But in 1970, the Sixth Circuit held that this standard was not permissible, that it did not apply, essentially stating that it was in violation of the constitutional rights of religion. So back to the whiteboard, essentially. But responding to this trend in 1971, Congress enacted the standard established by the EEOC. Tracking with the regulations, they stated that the term for religion includes all aspects of religious observances and practices, as well as belief, unless an employer demonstrates that he is unable to reasonably accommodate due to an employee's, reasonably accommodate an employee's or prospective employee's religious observance or practice without, as the EEOC said, an undue hardship on the conduct of the business. So as of 1971, that is the standard that employers have been working with. But still, it leaves a lot of gray area. And so we ask ourselves, what is the impact of that standard that had been established in 1971? Essentially, what it means for employers is that employers are required to accommodate the religious beliefs and practices of applicants and of employees. As I've discussed and touched on, Title VII defines religion very broadly. It does not include your traditional notions only of religion, but it also includes areas that you may not consider religious to yourself or to others, and it's not standardized to each person being the same. One person may have a religious belief, but the same practice or accommodation may not be religious for another. But as we would expect, religion includes items such as Christianity, Judaism, Islam, Hinduism, and Buddhism. But again, it does not require a formal establishment. So it doesn't require a formal church. It doesn't require a specific number of people, but specifically it needs to be a sincerely held religious belief. By way of example, something such as veganism has been found to be a religious belief. That does not mean that veganism across the board is a religious belief, but in that specific case, looking at the facts and the facts surrounding the individual's beliefs and why the accommodation was needed, it was found that veganism was a sincerely held belief at that time. But as you'll see as a trend throughout this presentation, it's important to really dig into the facts. So here, your first attempt into digging into the facts is questioning the religious belief. It needs to be a factual analysis. It needs to be, it's not standardized to a particular practice, as I said. It really needs to be a dialogue in engaging in what the religious belief is, where it stems from, etc. So I've tossed around the word reasonable accommodation a few times. And essentially that's a term of art here. And it's important to know for an employer's purposes, what is a reasonable accommodation? Specifically, a reasonable accommodation is an accommodation that eliminates the conflict between the employment requirements and the individual's religious belief. So it's not simply accommodating a whim of an employer or an employee. It's really focusing on what is creating the conflict here between what the business needs and what the religious belief requires. Again, it does not require that an employer provide specifically what the employee is asking for, but it needs to remove the conflict. So it can be any means of accommodation, but it needs to be accommodation that takes away that inherent conflict between both of those, the belief and the need of the business. So again, not the most beneficial accommodation in the eyes of the employee, does not have to be specifically the one being asked of, but it really needs to be, what we're looking at is the conflict, and it needs to be not a partial part of the conflict. It needs to be the whole conflict. If the whole conflict can be removed without an undue burden on the employer. And so when I say that undue burden, that undue hardship, that is an important standard that we'll discuss. And that is one thing that an employer is responsible for thinking of. But the employer has multiple responsibilities in regards to providing and engaging in this interactive process with the religious accommodation request. So first, the requirement it's important to note that the employer's requirement and obligation does not trigger until the employee provides notice. So typically, notice comes from the employee. It is the employee's obligation to provide notice. The employer certainly is not tasked with the burden of engaging with each employee to determine what possible religious accommodation exists. Rather, it's in the employee's job to provide notice of the need for accommodation and provide a reasonable understanding of why that religious belief is held and why it poses the conflict. With that said, an employer cannot turn a blind eye once they've been provided notice. So if the employer, it's not simply that the employer has a general sense that they have an inkling, they have a feeling, but really the employer, if they're put on notice in another way, one example would be if, for example, an employer were to call a prior reference, a prior employer of a job applicant. And in that case, the employer learns that the job applicant in the past had refused to provide contraceptives on the basis of religious beliefs. At that point, the employer would be on notice. The employer could not deny being on notice and could not fail to engage with the employee regarding their religious belief. And that brings us to our next requirement of the employer. The employer must engage in an interactive dialogue. Specifically, I've touched on this a few times. Generally, the idea of religious accommodations, it's a factual inquiry. So the employer is tasked with sitting down with the employee and engaging in an inquiry regarding what the accommodation requested is, why it's requested, and determining whether this employee has a sincerely held religious belief. It can't just simply be a whim, and if the employer, certainly employers have to be careful when they're engaging in this inquiry, questioning a belief. Typically, it would be our recommendation that you take most asserted religious beliefs as sincerely held, because it is a trickier area to delve into. But if an employer has past conduct that conflicts with the now represented religious belief, for example, an employee provides that they need an exception from a grooming or dress code policy because it is their religious belief that they are not to be clean shaven. But when they were hired, they were in fact clean shaven. That is a clear contrast to what they're now representing, and provides a basis to question that sincerely held religious belief. But again, in most cases, it is taken to be a sincerely held religious belief because it is a trickier area to question. Then in this interactive dialogue, it is the employer's obligation to understand why the accommodation is needed and engage in a process of determining what accommodations are available to remove that conflict. And again, this is removal of the full conflict if it will not impose undue hardship. But additionally, if it is the case that it will impose an undue hardship, which I'll get into, we need to at least attempt to remove a partial conflict if it's possible without an undue hardship. But I've tossed around the phrase undue hardship a few times now, and I'm sure that the primary question here is, well, what is an undue hardship to the employer? And when is it undue? Because that is the question that most employers, get stuck on. Most employers have to engage in that process. It's involving, looking at the business, looking at what possible ramifications are of providing each accommodation, not just the one requested, but all other ones that exist. So we'll dive into that now. And this is the most, I would say, the most key takeaway from today's presentation, because this is the most significant development in recent history. This was a change as of this past summer, June of 2023. The Supreme Court, in its decision, Groff v. DeJoy, looked at this issue of undue hardship. Specifically, in the past, there had been a much more employer favorable standard requiring an employer to only bear more than, or essentially stating that an undue hardship is where an employer is required to bear more than a de minimis cost. So though that is a pretty understandable term to most people, de minimis meaning a very low burden here. If it's throwing off the employer's business even a little, that could be considered an undue hardship. But this all has changed as of June of 2023, this past year, with Groff v. DeJoy. And looking at that, given the significance of the standard changing, I'm going to dive in a little bit about that case. Essentially, in that case, the petitioner was an employee at U.S. Postal Service. He was an evangelical Christian who believed that because of his religious beliefs, that Sundays should be dedicated to worship. He had been employed by the U.S. Postal Service since 2012, and upon his hire, he was not required to work on Sundays. With that said, his job requirements began to change because of the U.S. Postal Service's agreements with Amazon to provide services on Sundays. His location specifically was one of the locations that was tasked with Sunday service. And when that change occurred, he had decided to unilaterally make a change to a more rural postal office so that he could avoid this obligation to work on Sundays. Eventually, the U.S. Postal Service also was providing the Amazon Sunday delivery service on Sundays. And as such, he was again required by the U.S. Postal Service to work on Sundays. He, at that point, asserted that he required a religious accommodation in order to devote Sundays to worship. And it was at that point that the U.S. Postal Service started providing progressive disciplinary action for his failure to agree to work on Sundays. And as a result, he decided to resign from the U.S. Postal Service. Ultimately, he later brought suit against the U.S. Postal Service, alleging that under Title VII, that the employer had failed to fulfill their obligation of providing a religious accommodation. Applying this former standard, this much lower standard of de minimis cost, the district court had denied his claim, granting the U.S. Postal Service summary judgment. The Third Circuit did the same. They operated as was expected under this de minimis cost standard, and they affirmed that decision. But this is the key case as of late. The U.S. Supreme Court reversed, and they clarified under this newly established standard that an undue hardship is shown when a burden is substantial in the overall context of the employer's business. So substantial, obviously, contrasting these two standards, substantial is a much more significant requirement of showing a burden. Consequently, it's certainly we're going to see a shift in the cases coming out of Title VII. And they went on to specifically look at that, or to specifically elaborate that when the courts apply this standard, when they're reviewing religious accommodation or failures to provide religious accommodation, that courts must apply the test to take into account all relevant factors, including that the particular accommodation at issue, or including the particular accommodation requested, the particular accommodations available, and the impact in light of the nature, size, operating costs of the particular business. So, like we've mentioned, that didn't change too much in regards to having to look at the needs of the business, but it really does focus on what the burden is on the business and whether it is substantial. Like I've mentioned with religious accommodations, this remains a highly fact-intensive inquiry, with the court indicating that the standard now comports with the previous standard from Hardison, this former standard here, but now revising it to comport more with what we expect a hardship to be. Not in normal course, we don't think of hardship as this de minimis small item, but rather we consider a hardship to be something more, something substantial. So ultimately in Groff, they looked at the facts and they said that the U.S. Postal Service had only really considered what the accommodation, the request to not work on Sundays, how they would accommodate that by way of just providing overtime for other employees to fill his time slot, that they had considered only that one avenue to accommodate, and that wasn't enough. They considered other things that the employer could have done, was simply provide shift swaps. So Mr. Groff could have worked on Tuesday to cover one of his employee fellow employees a shift, and then they would work on Sundays. So they wouldn't be working an additional day. They would instead be working the same amount of days at no additional cost to the employer. So that failure was really the critical aspect of the case, given that the court was saying, it could be a substantial hardship here. It could be substantial, but you failed to consider these other accommodations and whether they are substantial. And therefore, the case was reversed. Out of this case, some factors that are important to note. One, they had considered, or many times, employers consider aspects of animosity that other employees may have because of the need to fill in, or in this case, swap shifts. Employees seeing that as favoring the religious belief, or because of the religious belief, people getting more favorable job circumstances. But out of the case, we see that that is not a factor that can be considered, this animosity that others may have towards religion or towards this accommodation. But with that said, a factor that is a key consideration for employers, and that has been proven to be strongly persuasive in the court, is safety. So that is a factor certainly that the court has found to be rather persuasive in regards to whether there is a hardship here. For example, one case provided that an employee was requesting, again, a grooming / dress code exemption. The policy provided that all employees had to be cleanly shaven. But in this case, the employer pointed to the fact that this is a safety concern, because here employees were working with toxic gases. And as such, the employees needed to wear protective requirement masks that would be impeded by any facial hair. In that case, strongly persuasive, certainly found to be an undue hardship, substantial in regards to what the business was here. In contrast, something in regards to something more just observation wise, in regards to wanting an employee simply to present clean shaven, not as persuasive if you're looking at it from like a marketing or advertising side. Another factor that courts have looked at and considered is this argument of the slippery slope. This argument that because you provide one accommodation, others are going to ask for this down the line. Certainly a very prominent concern in employers' businesses, but this is, again, like the argument regarding employee animosity, not a very persuasive argument for employers to take on. Certainly you can consider that. And we have seen it considered in regards to vaccinations, for example. But where it's proven to be somewhat successful in regards to vaccinations is because of this argument of a cumulative lack of vaccination in the business, and a threat that poses, not simply a concern because we're going to keep going down this line and have too many people asking for accommodations. That's a very key distinction. There's a seemingly more scientific, more analytical approach up to the argument regarding that vaccination, that, how do we handle a collective, essentially majority and or more of unvaccinated individuals, whereas in the other case of just a concern of having to provide too many accommodations, that is not as persuasive. With that, I wanted to discuss some of the typical types of reasonable accommodations. Essentially, these are just some of the ones that we have seen frequently in cases with the EEOC, and some of them I have already touched upon, such as flexibility in work schedule. So that being, allowing for more flexible comings and goings, with, as we saw in the Groff case discussed, with the establishment of the new standard, we have here shift changes and substitutions. So to allow for an employee to swap shifts, or to swap, to permanently change their shifts, that is a frequent type of accommodation to consider. Vaccine exemptions, as Jim mentioned earlier, this is certainly a prominent request. We've seen it before COVID, flu vaccinations, et cetera, but certainly it has increased prominence today. We've seen, as I've touched upon a few times by example, exemptions for dress code and grooming policies, also providing areas to pray, and assisting an employee to find an alternative position. These are frequent. There are certainly more accommodations to consider, but these are ones that are heavily prominent, and have been prominent even since the establishment of the new standard in June. As I'm sure everyone is very eager to hear about vaccine exemptions. I reviewed some of the recent EEOC dialogue on vaccine exemptions. They have recently, as of September of 2023, they have brought a case against United Health Services. And again, when we're talking about vaccine exemptions, it's, as always, a very fact-intensive process to consider whether or not to provide a vaccine exemption. And in this case, with United Health Services, the EEOC has ultimately filed suit, finding from their review that the employer had violated federal law when it discriminated against a full-time telecommunicator by refusing to grant a request for a religious exemption. In that case, the employee had worked from home since 2018, and as of that time, there was no policy for vaccination. Of course, when COVID came around, the employee imposed a universal requirement for vaccine mandate for all employees to get vaccinated. The employee then raised to her manager that she had been working from home since prior to the pandemic, and that she was requesting a religious accommodation. She was ultimately terminated as a result of her refusal to comply with the policy. In that case, the EEOC has brought a claim alleging that this was a violation. We have also seen this with flu vaccinations, and importantly, looking to, why the accommodation was needed, what the impact is on the business. Here, particularly with this case, the EEOC has viewed it as there was no business need, given that there was no risk at all associated with the fact of any spread, given that the employee was exclusively a work from home employee. The EEOC also has looked to grooming and clothing policies, dress code policies, as recently as September 26th of 2023. In that case, an employee who was a concierge was a practicing Muslim who had a beard. Soon after being hired, the employer provided their company policy regarding being clean shaven. The employee requested a accommodation, ultimately was terminated as a result. Again, their failure to consider accommodations, to engage in the process. As a result, the EEOC has brought a claim against the employer in that case as well. It's the case that in this list of accommodations, I provided assistance in finding an alternative position. And that's, I think, an important accommodation that employers should consider. An employer can help relocate an employee within the business. It does not necessarily need to be an equal opportunity, but an employer engaging in all of this to consider, the least ramification to the employee, and then offering that as an alternative is a type of reasonable accommodation that employers should consider when engaging in this dialogue with an employee. And importantly, which I neglected to note earlier, there is an obligation here. It's not just the employer who needs to engage in this interactive process. As I mentioned on notice, the employee has to provide certain information, but an employer is not the only one tasked with the burden of engaging in this process. An employee has to as well. So continuing to engage in this, not simply demanding that one-stop shop of my accommodation that I've requested, but engaging in the process of what possible accommodations could fit is tasked with the employee too. So that's something important for employers to note if faced with a particularly challenging employee's request or insistence on a particular accommodation. But overall, a takeaway for employers is that employers should be very cautious in imposing blanket bans against particular types of accommodations, because again, I'm sounding like a broken record, but it's a very fact-intensive process. So for an employer to simply provide a policy of we do not provide this accommodation is something to be very cautious of, because it really shows to the fact finder later, should you have a failure to accommodate claim be brought against the company, that as a whole, that there was a failure to consider at least that accommodation, and overall just an unwillingness. So certainly be wary of any attempts to provide a blanket ban of that sort. Certainly it can be discussed why this particular accommodation is a substantial difficulty for the business, an undue hardship for the business, and that can be discussed amongst the business. But to provide a blanket policy is something that businesses should avoid generally. And with that, that leads me into the best practices for employers and businesses. So kind of like I just touched on, but as a positive, there should be a religious accommodation policy. That should be something that is conveyed to employees. They should be made aware that they can ask for a religious accommodation. There are means of doing so. And with that, it is a preferable practice to provide an accommodation form. So that provides the questions regarding the accommodation. It provides the ability for the employee to provide notice. And certainly it helps with facilitating that interactive dialogue. So you can provide those questions on the accommodation form as to what the religious held belief is, what the accommodation requested is, what is at the core of this belief that creates the conflict. So accommodation forms should be something that are in that HR toolkit that businesses are using. Additionally, outside of the policy that the employers are providing to employees and making public along with the accommodation form, there should be internal procedures. So there should be within the management of the business known and discussed and established ways of how an employer is handling an accommodation request, and how the employer is engaging in that interactive process. Providing that structure will certainly ensure that all people who are engaging in the interactive process know their obligations. And so if the employer is faced down the line with a failure to accommodate claim, this can be provided. We provided our policy, we provided our form, we engaged as we should in the interactive process, and XYZ managers were on notice of their requirements and they complied. And as such, that leads to my last best practice is to provide the training, provide especially the managers, but those employees, the knowledge that they need to be equipped with in order to comply with both federal and state law in regards to the religious accommodation request and the subsequent interactive process. And particularly, as I noted, regarding state regulation, potentially providing a written determination at the end of the process. But importantly, in this best practice, there is that idea that this process should be documented, because at the end of the day, when and if a failure to accommodate claim is brought, it is the employer's obligation to demonstrate that this process was properly conducted and engaged in. And as such, the employer should be sure to document the process as they're going through this interactive process, what accommodations were considered, what was conveyed by the employee, etc. And of course, that ties back into the best practice of having the accommodation form, because that will provide a record of exactly what was represented by the employee as to the belief in the need. With that, there's some areas that employers can look for additional information on this. So here we provided a very base level understanding of what religious accommodations are, what they require from an employer perspective, and as well from the employee. But what now? So how do we apply those best practices? So one stop to look at is essentially, as we've discussed, the EEOC, because the EEOC has provided a very critical role in the development of Title VII generally. The EEOC provides very regular engagement in these issues, as I touched on, especially in regards to this new standard. The EEOC is really on the forefront of just looking at these issues before they've hit the court. So with that, I would recommend the EEOC website generally, but here I provided a link and the first page of the EEOC's own religious accommodation form. So if you're looking for a place to jump off from for applying that best practice of having accommodation form, here's a great spot to look. It's essentially providing what the EEOC themselves offers to their employees in order to request a religious accommodation. And you'll see here, they, exactly what I was discussing before regarding how this establishes a documentation of the request. It really evidences the engagement in the interactive process. So here's a great spot to jump off from. Additionally, the EEOC provides guidance. As one example, they do have a religious garb and grooming in the workplace rights and responsibilities guide. These guides are great. They have Q&As. So an employer who is faced with an issue, it's really a great stop, like a first stop to address whether or not what you're considering is a proper accommodation and whether you have considered all possible accommodations. And finally, I would recommend the EEOC newsroom. That is really telling you the latest in the developments of the EEOC and their application of these standards, particularly in light of the recent undue hardship standard change. This is really a wonderful place to look for how that standard is being applied. But additionally, looking at developments in case law, looking at the EEOC's past cases and establishment, that is a great stop for any employer who is feeling a little bit confused in this issue and this recent development. But with that, I have left some time for questions. I see that there is one question already in the chat, and so I will look at that. Okay, so as to the first question, it provides, if we cannot provide the full accommodation as requested, can we provide partial accommodation as a reasonable alternative accommodation? Or in those cases, should we simply deny the accommodation? You certainly should not simply deny the accommodation. As we talked about, it's really important to first engage in the process regarding a full accommodation. That's the first step. You need to go through the process of not just the one requested accommodation, as I've touched on, but all of the possible accommodations. You have to document why the undue hardship is being experienced, what's substantially impeding the employer's business. If the conclusion is made that the full accommodation cannot be provided because it truly is an undue hardship, and obviously having already determined that this is a sincerely held religious belief, then yes, you would look to whether you can provide a partial accommodation. And again, if you can provide a partial accommodation, if you can provide an accommodation in order to provide a different position within the business, those are certainly things to consider prior to any denial. You really want to document this process. The employee might not be in favor of the accommodation, but at the end of the day, it's not their choice of accommodation. It's just a reasonable accommodation to remove that conflict. So yes, certainly engage in the process, provide a partial if possible. As the second question, can you have a general company accommodation form versus just a religious accommodation form, as the interactive process occurs with all types of employee accommodation requests? It's certainly, you could do so. The religious accommodation form, you want to provide specifics. The ADA, for example, has a higher standard than that of the religious accommodations. So preferably to separate out the two forms in order to document that you have met the proper standard. But if you provide clearly different sections in regards to the differing needs for accommodation, delineating as such, at least that can provide documentation of those two. But you really want to distinguish, because again, the ADA has a higher standard, the religious accommodation is a lower standard, and you want to document that the issue being discussed is the particular issue here, religion, or here a disability. So it's certainly a preference of the employer, but making sure that those are properly documented, it would be my recommendation at least to delineate accordingly on the form if you're using a uniform form. But you certainly want to provide the notice to the employee that if it's a general accommodation form, that it is covering religion, it is covering a religious accommodation, and a heading of such may cover that. As the next question, how would you handle if an employee wears offensive religious clothing and other employees have complained about it? So in that, it's engaging in the process. It's addressing the religious wear. Are they wearing it because of their sincerely held belief? Is it because of their religion? Is there a rule that they're wearing it? That is unlikely to be the case. But if that's the case, then you would of course have to proceed with it, whether there's a possible accommodation. But again, as I touched on, animosity alone of other employees in regards to their religious belief is not a basis for undue hardship. So first determining why they're wearing the offensive, quote unquote, offensive clothing. But if it's in fact the case that their sincerely held religious belief isn't the reason that they have to wear this clothing, then it's a form of expression. And as such, this is kind of a hot topic issue, but at present, but it's important to note that in the private sector, there is no freedom, the right to speech. So you certainly want to toe the line very carefully in this, but the employee doesn't have the right to wear offensive clothing. That doesn't stem from a religious accommodation if it's not as a result of their beliefs that they are wearing the clothing. So if that, I believe that addresses the question, but if you have any follow-up on that question, please let me know. As to the next question, you mentioned that finding out that an employee may need an accommodation from a former employee counts as the employee providing notice. Are we on the hook if we find out in other indirect ways, like references, social media, etc.? So you as an employer, you do not want to be put in the position where you are painted as intentionally turning a blind eye to it. So if it's the case that you're made aware directly of the need for an accommodation, it's best to err on the side of yes, that you've been provided notice. But with that said, it's not just a general sense, but it would have to be a more specific form of notice, not simply that, for example, you have noticed that they attend this church or they have gone to this organization. It needs to be that they cannot work on Sundays, or they cannot shave their beard, something more concrete than a simple general sense. But if you're on that gray area, you certainly should err on the side of having been provided notice and engaging in that interactive process. Especially, something in social media, you'd have to look at the contents of that social media, what it is that they're providing. If they're just simply providing a resharing of a symbol of sorts or something of that nature, that might not elevate to the level of notice of a need for a religious accommodation. That could be any manner of things for the rationale for why they're sharing that. As the next question, does this process apply to minors in a high school? I have a student who wants to wear a veil because she is polytheistic. We ordinarily do not allow baseball caps, hoodies, etc. This is in regards to employers. So again, touching back to what a covered employer is under Title VII, you certainly you have to have more than 15 employees, etc., as the requirement goes. So looking at that basis, it's unlikely that a high school is not an employer of a student. But with that said, it's certainly the case that there are other applications in regards to what expression is allowed in regards to religion in high schools. So while this framework does not apply, it's certainly something to critically analyze, and likely would need some type of accommodation, but not under this framework. And I'll give a minute for any additional questions. But in summary, if we have no further questions, as you can see, this is a evolving area. Given the recent decision in June of 2023, the standard has shifted. Employers really need to take on this task. They need to engage in this task, and they need to take it seriously, because the standard is no longer just that low burden. It's now, what is it substantially impeding, and what is it in regards to the employer's business that it's substantially impeding. As you're doing this, consider those best practices, make sure that all of your employees are properly trained, and additionally, make sure you're engaging intensively, case-by-case basis, in the facts of each request of each religious belief. There's no one size fits all in a religious accommodation, so make sure that you're engaging in each of these processes. And with that, I want to thank you all. As to the credits, as Jim touched on, Liz Tisak will be reaching out in regards to the credits. And I don't believe there are any additional questions. As she mentioned previously, these slides will be, as Jim mentioned, these slides will be circulated, and certainly reach out if you have any additional questions to Liz. But I do recommend the EEOC's services in regards to their guidance, and keeping an eye on their newsroom as well will help employers to stay in touch with all of the recent developments. And with that, I thank you all for attending, and I hope that you can join in our next session.